everyone, welcome to video lecture 7 on ASEAN and security. So from seminars 1 to 6, we looked at the laws and institutions of ASEAN, the frameworks, and now we are fully equipped to look at seminars 7 to 11, where we use the tools that we learned in the previous 6 weeks and apply them to the 3 community pillars of ASEAN. For seminars 7 and 8, we're looking at the ASEAN Political Security Community. For seminars 9 and 10, we're looking at the ASEAN Economic Community. And for seminar 11, which is the last seminar, we are going to look at ASEAN and its external relations. So let's focus on seminar 7, ASEAN and security. Again, let's come back to our principal norms, which are power, laws, policies, and institutions. These are the concepts which need to be at our forefront of our minds as we use the skills that we have learned and apply them to the ASEAN political security pillar and the issues therein. So there are 2 types of security when we do security studies, whether in law or in international relations. Generally speaking, there are 2 types of security. One, which is the military or hard security pillar. So you might come across this in various literature. So when the term is hard security, we mean armed security, military security. And this is usually found within the ASEAN community of the first pillar. Okay? And another term that we see very frequently in security is comprehensive security. And this deals with the non-military aspects of security. So human security, comprehensive security, economic security, health security. So all things which impact on security but are non-military can be encompassed within comprehensive security. What comprehensive security does is that it cross-cuts the second and the third pillars of the ASEAN community as well as the first pillar. Okay, so these are some of the scenarios where ASEAN security has been focused upon, right? In the December 2004 tsunami, then the cyclone Nargis in Myanmar, as well as a more military security issue of fishing boats incursion into territorial waters. So this is where the Indonesian Navy or police blew up trespassing Chinese fishing vessels. What are the issues that we need to keep in mind when we explore the subject of ASEAN and security? So as I mentioned, hard security and comprehensive security. So this slide will talk about the more concrete example, right? So armed conflict, it could be border issues, territorial issues surrounding sovereignty, national sovereignty. And of course, the South China Sea is also an ASEAN security issue where we look at maritime territorial disputes. It can be, rocks, formations, land, territorial disputes over hard land or territorial waters. In comprehensive security, these are the issues that we have seen in ASEAN broad. They encompass broader socio-economic aspects, which is why comprehensive security also cross-cuts pillar 2 and pillar 3, right? Socio-economic aspects. And then, as I mentioned, health, which is very important today in our COVID-19 pandemic times, humanitarian missions. So this would deal with natural catastrophes, and where the ASEAN task force, a humanitarian task force, will need to be sent to these ravaged zones, right? And human rights, which belongs in the first and the third pillar, and environmental aspects of security, environment, climate change, rising sea levels, rising temperatures, so on and so forth. So in all these ASEAN and security issues, remember what I said regarding the 4 key concepts, right? We need to look at powers, external powers and their influences, small states within ASEAN versus bigger states within ASEAN, or small states in ASEAN versus bigger external states, right? And more importantly, how do ASEAN members respond to these external powers? Do they respond collectively or individually? And usually we will see a varied response where both collective and individual responses are registered. And then we also need to see in ASEAN security matters, are we using law, or are we using more policy and diplomatic negotiation, right? And also, since ASEAN member states are very sovereignty and state-centric, are there any limits to, the non-interference arguments? So these are the comprehensive issues that we need to keep in mind. Looking first at military security, this is a term which we need to really understand. Non-intervention, right? This is really the most important norm or principle in the UN Charter, in the contemporary global order. What does it mean and what does it do, right? So we also need to understand where this principle of non-intervention is enshrined and how it arose. Apart from that, we need to see the exact parameters of the principle of non-intervention. So all this you will be able to find in the seminar sheet and the literature and the questions that deal with the principle of non-intervention, but I will flag out some clues here. Non-intervention deals primarily with the use of military force, or rather the proscription against the use of military force. So non-intervention means that you cannot use military force to intervene in the territory, whether land or water, of another state. It is a key principle of the UN Charter, the non-use of force provision, right? And we also need to understand, are there differences between the Western and Asian views on non-intervention? Here we come to non-interference, and this is the term that ASEAN states like to use. In literature, in international law literature and international relations literature, the term used is usually non-intervention. In the ASEAN context, we tend to prefer to use non-interference. Sometimes scholars and practitioners mix up the two terms, non-intervention and non-interference. There is a clear distinction between non-interference and non-intervention. To begin, non-interference is arguably the most important principle in ASEAN, right? And so we need to understand what this norm is about, where we can find it, where in the Charter or the ASEAN instruments, right? And to answer the question, the critical answer of whether there's a difference between non-interference and non-intervention, the thing to bear in mind is military force, right? As we understand, non-intervention is the proscription against the use of military force, whereas non-interference generally means, poking your nose into other people's affairs, right? Diplomatic interference or verbal talking or criticism against a neighbor, that is usually categorized as non-interference. So non-use of force type of interference. In intervention, the terminology that is associated with intervention, as I mentioned, use of force, or humanitarian intervention, where armed forces forcibly enter another territory in the name of human rights. And also there is the contemporary concept of R2P, which is the responsibility to protect, right? The state responsibility to protect. So that has to deal with intervention. Interference, non-use of force, commenting or criticizing other states. Things that we should bear in mind and understand more deeply, and we will discuss this in person in the seminar, is that ASEAN steadfastly proclaims the adherence to the principle of non-interference. I think it's very important that everybody forms their own opinion on the extent to which ASEAN or ASEAN member states adhere to the principle of non-interference. Do you agree that ASEAN member states always never interfere in other member states' affairs? Or do you think there are instances, or even many instances, where ASEAN or ASEAN member states violate the principle of non-interference for a greater good, right? There are obviously implications of the principle of non-interference on ASEAN's comprehensive security, right? This principle of non-interference came up, one of the biggest and earliest times of it cropping up was during the 1997 financial crisis, where ASEAN member states discussed whether to, mitigate the principle of non-interference, right? Because of the disastrous effects of the Asian financial crisis that had transnational effects. Some ASEAN member states felt that, it was important to voice up issues that were happening in other member states that could be detrimental to the rest of the region. And obviously natural disasters are also an important situation where sometimes the principle of non-interference could be breached, right? If there's a natural disaster and you want to go in with a humanitarian mission, right? A humanitarian mission is not humanitarian intervention, but a humanitarian mission to give Red Cross aid, so on and so forth. That is actually also a form of interference. And when there's health pandemics, right? For example, COVID-19 as we're living through, or Zika or SARS, should there be, a mitigation of the principle of non-interference? So issues which come up in difficult situations where ASEAN member states want to, mitigate the principle of non-interference, it might occur that it seems to the outsider that sometimes there seems to be hypocrisy and political duplicity regarding the principle of non-interference and how it is practiced, and also practical exigency when the principle of non-interference is practiced. In all these situations, we also need to bear in mind where the law is in all these situations. As mentioned in the previous slide, ASEAN member states have actually discussed the issue and the norm regarding non-interference. In all our previous week's readings and also in week 7's readings, we understand and we know that the principle of non-interference has time and again cropped up and posed problems to ASEAN member states. For example, in human rights, if the principle of non-interference is raised, then ASEAN is open to many criticisms, right? because by nature, the human rights discourse is one where the public should have scrutiny and transparent input on how their rights are being enjoyed and how their rights are being managed. So, and there are other situations as well, right? As I've given the 1997 Asian financial crisis, there may be situations in which non-interference should be lowered or done away with so that we can protect ASEAN people. So the question that we need to answer is, should the practice of non-interference be modified? And if it should be modified, how should it be modified? Under which circumstances can we change or modify the non-interference principle? In your readings, the 1997 or in the fires and haze crisis in the 1990s raised the issue of modifying the principle of non-interference with the principle of flexible engagement or participatory regionalism, which means that ASEAN member states may be able to raise, voice, air their grievances about certain national practices of other member states, if it has negative effects on the rest of the region. But of course, flexible engagement and participatory regionalism, while they were discussed, they were not successful in changing the non-interference principle. So the non-interference principle still remains in ASEAN, and the debate continues on how and when the non-interference principle can be changed, right? So how should we modify it? How should we modify the practice of non-interference, yet not raise overt politicization? There are three plausible parameters. One is when there are extra-national or transnational implications of security challenges. So this would help justify when some sort of interference is necessary. And of course, even if there is interference, it cannot be unlimited, right? So a second parameter is to set clear limits on what these comprehensive security issues are that interference can be triggered. And lastly, if we are going to deal with the tricky security issue, how are we going to deal with it? How are we going to interfere? So there needs to be clear modalities on how and the methodologies that ASEAN member states will deal with the comprehensive security issues. Having understood these principles and some of the parameters of how they can be used, we now turn to the case studies and application of these principles. So we need to see, as I've mentioned before, the movement from policy and diplomatic negotiation towards increasing legalization and a greater rule of law. For a simple case, let's look at the temple of Preah Vihear, where Cambodia and Thailand brought the case before the International Court of Justice. So what this dispute was about was the disputed land surrounding this temple. In 1962, the International Court of Justice gave, the temple of Preah Vihear to Cambodia, right? But the border surrounding the temple site was left inconclusive, and this led to years of border tension. So you can see from the slide where the disputed area is. What happened next? Well, So in 2007, shortly around the time of the signing of the ASEAN Charter, so for 4 years there was the reignition of the border dispute. Cambodia wanted UNESCO accreditation for the temple, and its submission to UNESCO, to the UN, included the map of the surrounding area, and obviously Thailand protested, right? And the map was withdrawn. But then, because of Thailand's internal unrest at that time, the border skirmish or the border conflict was exacerbated, and Thai ultra-nationalists crossed into the disputed area where military troops were mobilized. There were bilateral negotiations, consultation to resolve the dispute, but the dispute continued to fester to the extent where Cambodia escalated it to the UN Security Council and also alerted ASEAN, in which case Indonesia offered to set up, a contact group and to facilitate good offices, mediation, such that negotiations could continue, talks could continue. Thailand declined this offer because it insisted on bilateral dispute resolution, and tensions just rose again, such as Singapore, who was ASEAN chair at that time, called for restraint on both sides. Vietnam, who was then the United Nations Security Council monthly president, advised that the member states to keep the matter within the region. There was no support from China or the US on the UN Security Council, and therefore Cambodia's request was withdrawn. There were further skirmishes which resulted in deaths, and Cambodia again appealed to the UN Security Council. In the meantime, Indonesia, who was by then ASEAN chair, tried to facilitate resolution of this dispute, and this was an extension of its mandate beyond the chairmanship. So there was some uneasiness about, how Indonesia tried to facilitate good officers. By which time, in 2013, the Court of Justice ruled that temple and the immediate area belongs to Cambodia. So it kind of reiterated, but went into the immediate area to say that it belongs to Cambodia, and the border area remains unresolved. So this is an issue or an example of hard military security issues and how they're dealt with in ASEAN. And we have also discussed how, in dispute settlement, ASEAN member states have tried to deal with these problems within the region, but sometimes member states prefer to bring it to external arbitral panels. One thing regarding international dispute resolution, especially when it deals with political and territorial issues before the International Court of Justice, is that the decision will try to reach a win-win solution with one victor, but a compromise in the other issues. So, for example, down here we see the temple and immediate area belonging to Cambodia, but the Court of Justice did not decide on the border area, so it left it open. This was the same regarding Petra Branca, the Petra Branca case that went up to ICJ between Singapore and Malaysia. Singapore won the case, right? But then left the overlapping territorial waters to Singapore, Malaysia, and Indonesia to resolve through negotiation. Another security issue is Cyclone Nargis. So this is the humanitarian catastrophe that was talked about earlier. In Cyclone Nargis, there was this state of emergency, and the Myanmar government was overwhelmed. Right? There was international disaster relief efforts being called upon. The United Nations, Red Cross, and other international organizations were waiting to get into Myanmar, but the Myanmar government, although it was overwhelmed, did not want international organizations to come in to distribute aid, right? So it blocked aid relief, and there were ships in the waters with medical supplies and so on and so forth, waiting to help the Myanmar people, but they were not given access by the Myanmar government. So it was a real humanitarian crisis, such that the international community discussed the principle of the responsibility to protect and humanitarian intervention. So these were largely Western calls that, let's just go onto the land and distribute aid, even if the Myanmar government opposes, right? However, Russia and China opposed such calls of humanitarian intervention because it is a gray area. There were obviously local relief efforts, but local relief efforts in conjunction with the NGOs on the ground, but these were somehow penalized by the Myanmar junta, who was the government of its time. So the real breakthrough came through ASEAN's regional relief efforts, where, thanks to personal political connections, bilateral relief efforts, and a lot of intense good offices on the part of ASEAN, where ASEAN negotiated with the Myanmar government to allow international organizations to bring aid relief in, and the Myanmar government finally acquiesced, and they said, okay, the aid relief can come in as long as ASEAN manages the flow and the direction in consultation with the Myanmar government. And so the relief aid did reach the Myanmar people, but this was after about 2 weeks, right? So ASEAN's response, how it managed this, was to give the Myanmar junta 3 options. You either let the relief efforts come in through the UN or ASEAN, or you will suffer, humanitarian intervention, or even or R2P, right? So the Myanmar government agreed that ASEAN should manage the relief efforts. And how the Cyclone Nargis relief aid distribution was managed is deemed rightly as a success in Myanmar security intervention. And the question is whether, Nargis and how ASEAN dealt with Nargis is a test case to be used in future. So I think there are certain indications of this because ASEAN has been working quietly on the Rohingya issue and for the repatriation of the residents. And of course, when we talk about territorial disputes and security in ASEAN, we cannot leave out the South China Sea. So this is a long-running dispute. Even if it seems very current, it's not, because it has gone on for decades. So now in the South China Sea, we can see, the issue being the 9-dash line, which is where China claims its territorial waters are, and that's the red dotted line, whereas under the UN Convention of Law of the Sea, right, UNCLOS, countries should only have a 200 nautical mile exclusive economic zone, the EEZ, right? So that's the blue dotted line of every state and its territorial waters. So you can see very clearly from this map why there is a maritime territorial dispute, because the Chinese claimed territorial waters cut through the claimed territorial waters and the rightful territorial waters of ASEAN member states. There are also other issues arising in the South China Sea dispute, where there is the intense militarization of the South China Sea and the building up of lands in the South China Sea. So you can see the reclaimed lands in South China Sea from the Chinese army, the PRC army, and of course there are also, discussions and also arguments over the US Navy's presence in the balance of power in the South China Sea. In the South China Sea dispute, who are the disputing parties, right? Obviously there's China and the other territorial states, some of whom are ASEAN member states, so Brunei, Indonesia, Malaysia, Philippines, and Vietnam, and of course there's also Taiwan. The timeline of the key events regarding the South China Sea dispute can be traced back, I guess, most prominently in the 1990s, right? So although there were tensions already, but the ASEAN member states issued the first South China Sea statement that, this is a very tense issue and there should only be peaceful resolution taken over, South China Sea claims, because any type of action could severely destabilize the region. A year later, in 1996, the ASEAN ministerial meeting suggests that there needs to be a regional code of conduct in negotiation with China, right? But the obstacles that lie in the wait of the concluding of this code of conduct have to deal with the works and habitation of the South China Sea features, what's the area of application of the code of conduct? Is the code of conduct a legally binding one? What is the role of ASEAN in, drafting this code of conduct when not all ASEAN member states are claimant states? We fast forward to 2007, where ASEAN and China exchanged draft codes of conduct and they initiate negotiation. 2 years later, these negotiations stalled, and instead of a code of conduct, we get a declaration on the code of conduct of the parties in the South China Sea. This is a non-binding political statement because the code of conduct is still being negotiated. In 2005, a DOC working group was formed to work towards the code of conduct. In 2010, a new code of conduct draft made by ASEAN was circulated about ASEAN members. It was never formally offered to China for consideration, right? And then in 2011, nothing moved on the code of conduct, but guidelines to implement the declaration on the code of conduct were adopted via consensus, and implementation of the DOC was started in 2012. But of course, there was a standoff between Philippines and China, and there was the PCA arbitration. In 2012, Indonesia took the lead and obtained consensus on the 6-point principles on the South China Sea that reaffirmed, the full implementation of the DOC, the guidelines for implementation of the DOC, and called for, the conclusion for the COC, for the Code of Conduct, in accordance with the United Nations Convention of Law of the Sea, UNCLOS, and continued self-restraint and non-use of force. So there needs to be non-intervention by all parties to the South China Sea dispute. And all disputes regarding the South China Sea needs to be peaceful and in accordance with international law, including UNCLOS. But by which time Philippines unilaterally initiated the arbitral case at the PCA, and by 2016-2017, the arbitral tribunal finds favor with Philippines. The Duterte chooses to set it aside, by which time the ASEAN states adopt a COC, Code of Conduct framework, and at the end of 2017, ASEAN and China were looking towards a binding code of conduct, but up to today, we do not see any real end or any real conclusion to the code of conduct, although it is an annual aspiration to conclude this code of conduct, which now all parties to this code of conduct do seem to agree that it needs to be a legally binding hard law. So ASEAN's role in the South China Sea, although it is an ongoing saga, our role as jurists, as international lawyers, to observe and to analyze what ASEAN's role is in the South China Sea dispute. Does it have one? And what has it done? And what about the other powers in the region? What are their roles in the South China Sea dispute? What do states mean? What does the international community mean when the rule of law is to be upheld regarding the South China Sea, right? And is there a real role for ASEAN law and policy and international law in the South China Sea? So arguments in favor of international law is in the United Nations Convention of Law of the Sea, the Treaty of Amity and Cooperation, the arbitral ruling, right, the DOC, and the binding potential code of conduct. And if we are looking at the tensions between law and power, what is the role of other powers such as China, Australia, India, Japan, the US, and the EU, right? And obviously in international law, there is historical title and effective control, right, to the territorial lands and waters of the South China Sea. Who can demonstrate most historical title and who can demonstrate most effective control? In ASEAN, is there a role for neutrality? Who has a role for neutrality and how is it going to be played out? Are there bilateral or should there be multilateral negotiations to resolve the South China Sea disputes? And we also need to understand how powers and political leaderships shape how the South China Sea dispute is being managed. Coming now to the pandemic that we are living in, ASEAN and COVID-19, this is obviously a human security issue, and we need to bear in mind what aspects of human security emanate or have resulted from this COVID-19 pandemic, and how have these security issues evolved through this pandemic year, and where are the powers and the politics. Obviously, the power and politics have emerged even more strongly regarding the production and distribution of vaccines, and is there law at all in the manage of this COVID-19 pandemic? So issues to bear in mind are that, in the COVID-19 pandemic, from what we have seen in the South China Sea to this pandemic that we are living in, we move from the first to the third pillar. In a pandemic, in a health crisis, it's really increasingly what we look at are socioeconomic issues, right? The pandemic has definitely affected our health, so that's a socio issue, and it has also affected our ability to work, and that's an economic issue. So, and if we do not have jobs, if there is rampant unemployment, that is a severe socioeconomic issue. Public health and policy also impacts severely on national security, right? So as we have seen in the pandemic year or pandemic years, emergency powers were issued, there was mask wearing, constitutional rights were impacted on, freedom of movement, the right to work, the right to education, all has been impacted on. And then there was the unilateral action of coalition of the willing on, freedom of movement, air traffic, vaccines, so on and so forth. There was a mixture of bilateral and regional action, right? Where were ASEAN dialogue partners involved in ASEAN's management of COVID-19? So the dialogue partners provided capacity in terms of data, tracking, movements, ASEAN emergency rice reserves. So during this pandemic, even when we had shortages in the early parts of the pandemic, at least there was no starvation, right? And over the pandemic, I think how ASEAN has managed the COVID-19 crisis is not about finger pointing or blaming who started the pandemic, but ASEAN efforts were really about human security and public protection, right? Increasingly, as the pandemic continues, the human security issue has turned more to vaccine production and distribution, and also economic, such as tourism, food supply chains, and workforce issues. Coming now as we conclude this seminar, let's recap the issues and the concepts that we need to bear in mind. We have looked at heart security, right, from the temple of Preah Vihear to the humanitarian security issue of Cyclone Nargis. We have also looked at the South China Sea, and we have looked at the contemporary problem of the COVID-19 pandemic. So we have looked at two heart security issues, and we have looked at two comprehensive security issues. So now stepping back and to look at ASEAN as a holistic security community, can we try to characterize the type of security community that ASEAN is? What is ASEAN's security community's strength? What are the norms which guide ASEAN as a security community? And how effective is ASEAN as a security community? The issues and the norms and principles which impact on the strength and efficacy of ASEAN as a security community include the size of the external or regional power, the political and economic influence that these powers have, the political leadership of that power, that state, whether there is a presence of other external, international powers, and the level of persuasiveness these powers have. And finally, when we deal with ASEAN as a security community and external influences are quite strong, we also need to ask ourselves the extent to which ASEAN centrality, or the extent to which ASEAN is in the driver's seat. What is the degree of ASEAN centrality? And with that, I conclude this lecture, and we look forward to exploring these themes more deeply in the seminar questions. Thank you.